Please rise.
Please be seated. Both Royce and Royce, City of Jacksonville.
Yes, Your Honor.
Tell me who should be.
Your Honor, Howard Royce, I would like to reserve 4 minutes for rebuttal. This case, Your Honor, is concerning a order from the Fourth Judicial Circuit. It's at tab 1 of the appendix that the appellate have provided to the court. Judge Mitchell's order essentially validated the respondent's usage of administrative res judicata during a quasi-judicial public hearing conducted on 7th February 2006. The issue before the court is the applicability of res judicata to the quasi-judicial hearing. There's 2 schools of case law. One is from the first DCA, which was Doheny versus Grove, that's 442 Southern the 2nd, 966. And at 970, Judge Nimmons wrote a dissenting opinion. And then the dissenting opinion was eventually adopted as the opinion of the court upon rehearing. And specifically, Doheny holds that new facts, changed conditions, or additional submissions by the applicant may materially affect the applicability of res judicata or estoppel by judgment. And it's interesting because Doheny came after Coral Reef, and Doheny actually cited Coral Reef. Doheny was supported by Thompson, that's a Florida Supreme Court case, 1989, 511 Southern 2nd, 989. And at 991, the court acknowledged Coral Reef, which is the second school of thought. And the court specifically in Thompson followed Doheny, specifically followed the First District Court of Appeal. And they cite specifically at 991 that the proper rule in the case where previous permit application is denied and said res judicata will apply only if the second application is not supported by new facts, changed conditions, or additional submissions by the applicant. Now,
But here we have the same property, and the petitioner here acted as the owner's agent in the first proceeding, where there was a full hearing, and is the successor in interest to the original owner. Are you saying, what are the additional facts?
The additional facts are specifically in the record of the new application, new owners, the additional permits that were pulled, and that there had been 5 years that had elapsed between the initial proceeding that was before the Planning Commission of the City of Jacksonville and the Land Use and Zoning Commission. And it's interesting, and I'd like to regress for a moment. It's interesting because in Coral Reef was a 1982 case out of the 3rd DCA. And we don't suppose that the first DCA adopted Coral Reef, but Coral Reef has a criterion of substantial change in circumstances. And that's where we think not only the error in the quasi-judicial hearing occurred, but also in the Fourth Judicial Circuit by effectively adopting Coral Reef in direct opposition to Thompson v. DER and subsequently Doheny versus Grove, which is from the first DCA. That Coral Reef case cited the Metropolitan versus Dade. Coral Reef is 410 Southern 2nd, 468. And there's numerous sites, which I can provide to the court if necessary, as to where not only in the quasi-judicial hearing, but all through the pleadings of the respondent, they cite the substantial change requirement rather than the requirement that the second application be supported by new facts, change conditions, or additional submissions. And additional submissions and the new facts were acknowledged by the Land Use and Zoning Commission.
But how is the fact that it's a new owner, especially where the new owner represented the prior owner, how is that a substantial change of circumstance? How is just the passage of time a substantial change of circumstance?
Well, there's a standing issue, Your Honor, according to the procedure that the city has in place, and that's within their ordinance, which is 633-133 and 656-136. And it requires that for you to make application, you must be the lawful and legal owner. Without being the lawful and legal owner, you have no standing to make application on a parcel of land that you do not own. So once the land has changed hands to another owner, then that new owner has a cause of action to come forward to apply for a waiver under the ordinance as promulgated by the City of Jacksonville. Because if we were to follow that event, Judge Van Noort, then any subsequent landowner would be bound by this order that was in 2000, specifically citing Carol Olson. And there's not an identity of parties there. Carol Olson may be bound by res judicata, but not any other party. Not any other party that's in this room or any other citizen. And we think that's a fundamental error. We haven't gotten to the points on whether or not the 4 issues of res judicata apply. The first portion is to get past the requirement that the wrong standard was used. This is the standard that was used throughout the quasi-judicial hearing and throughout the pleadings as presented by the respondent City of Jacksonville is a substantial change of circumstances. We proffer that is the wrong standard. The correct standard is in Doheny as supported by Thompson. And to apply res judicata, you must go in and say what standard was used. And the standard that was used is clear. The standard that was used is substantial change of circumstances. That's not a factual issue that needs to be made. That's in the record. That's what the order says. That's what the ordinance says. That's what the legislation says. There is a separate issue that comes to bear, which was there should have been an order from the Land Use and Zoning Commission rather than a legislative enactment. And the sign on this is the ordinance section 656-136B. And it says a final order in each application for exception or variance, a waiver, or each appeal shall be issued within 15 days. What the city actually did was created an ordinance. And so we went up and on first writ to the Fourth Judicial Circuit, looked at the ordinance rather than an order. That was a second procedural violation that made this different from the Planning Commission. And I say I would like to reserve my time for rebuttal.
May it please the Court. My name is Jason Teal. I represent the City of Jacksonville in this second-tier certiorari review of a first-tier circuit court opinion upholding the decision of the City of Jacksonville to deny a waiver of road frontage application on the basis of administrative res judicata and administrative finality. Because this court is sitting in second-tier certiorari review, its narrow jurisdiction is limited to a determination of whether the circuit court afforded procedural due process to the petitioners through proper application of the essential requirements of law. Instead of understanding this limited jurisdictional review, petitioners would, in their brief, or in their petition rather, request this court to take what amounts to a de novo review of their waiver of road frontage application that the City of Jacksonville denied twice. Originally denied it in 2000 on the merits, and then denied it again in 2005 through the procedural issues.
So is it your position that here, as a successor in interest, the petitioner here is bound by the doctrine of res judicata?
It is, Your Honor, in part. We think that there are two separate legal doctrines that apply here. The first is the concept of administrative finality, which courts have blurred that with administrative res judicata. Basically, the administrative finality is the concept of providing a termination to legal proceedings or administrative decisions so that members of the public or the parties can rest assured that that's the decision that's in the books, and it's not, you have to keep looking over your shoulder to make sure that, that the applicant's not going to come back and try and wait until the parties have changed, so to speak, the elected officials, and maybe get a different result. The second issue is with regard to administrative res judicata. And, Your Honor, it's exactly the city's position that in order for that concept to apply, there has to be a simultaneous occurrence of 4 identities. And the one that you referred to, Judge Van Noort, is the one with the identity of the parties. Now, what the petitioners would request this panel to do is to look myopically at the fact that the name on the first application is different from the name on the second application. What that ignores, however, is the fact that it's well settled in case law that the identity of the parties there's not a strict requirement for identity of the parties. First of all, they failed to mention in their 2000 application, as the court has already alluded to today, that they were specifically designated as the agents for the former landowner, that they actually participated in intimate detail in both the submission of written responses to the city staff report and appearing live at the actual hearing in the 2000 application, where they described themselves on the record as having a fiduciary duty to adjacent property owners due to the fact that they would be the personal beneficiaries of the waiver. Florida courts have recognized various situations where strict identity of the parties between multiple applications is not mandatory. Specifically, it's been held that where a person participates in a prior proceeding, and the language that's used is where his conduct is such to give him the status of a party in actuality, if not formally named as a party, he is bound by the prior judgment in that proceeding. Additionally, a successor in interest to a party is bound by res judicata due to the nature of the relationship and privity. Petitioners purchased the property.
There are two big reasons that the petitioner is bound. One, the participation in the first proceeding, and second, by virtue of the fact he's a successor in interest.
Correct.
But what about other facts? It seems to me, while just the passage of time may not be sufficient, suppose the development surrounding their waivers granted to neighbors, would those sort of facts allow someone to come back and seek another waiver?
Absolutely, Your Honor. Before we leave the previous point, there's actually a third ability for strict identity of the parties to not be consistent, which is the concept of virtual representation, which basically means that the second applicant stood in the shoes of the first and virtually represented the interests of the parties. Getting to your second point, that's with the doctrine of administrative finality. In essence, that doctrine says you can't have a successive application unless there's been a substantial change in circumstances. And that was the specific finding of the city council, or the specific review of the city council in this case. They did have a hearing. They had a hearing to actually, where they asked the applicant, what are the substantial change in circumstances between the 2000 application and the 2005 application? He was only able to articulate at the city council only two. He's now come up with a third one of the passage of time. But the two that he was able to articulate were that the names on the applications were different and that he had pulled a bunch of permits and done a bunch of work on the property itself in the intervening time. Now, the city's position with regard to that second point is he's proceeding at his own risk at that point. He was on notice in 2000 that he was denied a waiver of road frontage, which is his ability to develop that property. He mentioned during the 2000 hearing that what's the process for developing this property? He said, I'm going to need this laundry list of permits, and I'm going to need this to do this work. So he presented that to the city of Jacksonville in 2000. Merely the fact that he actually did some of that work is not a substantial change in circumstances. What the law requires as far as the distinction between the two applications is there has to be so significant a change such as to actually make it into a new application virtually. So that's the level of change that needs to occur. The identity of the parties isn't in effect in this case because res judicata is applied to different folks than were on the first application in those three instances. Additionally, the work that he did, that's not even relevant to what the criteria is to determine whether or not a waiver of road frontage is appropriate. So he's got a problem on that front as well. It was presented, res judicata precludes not only what was presented, but what could have been presented in the initial application, the arguments. But more importantly, his substantial change in circumstances don't even go to what the criteria is that the city reviews waivers of road frontage under. You referred in the last case before the panel the city of Alachua having its laundry list with its catch-all of in the public interest. Similarly, the city of Jacksonville has the same situation dealing with waivers of road frontage. There are 5 criteria that have to be considered whether it's appropriate to relax the zoning code, strict requirements of the zoning code in specific instances. And developing the property is not relevant to any of those 5 criteria. So the other issue that they draw the court's attention to with regard to the res judicata issue is the identity of the cause of action. Now, the Florida Supreme Court in Florida Power Court v. Garcia, which is 780 Southern 2nd 34, 2001 decision, defined what the identity of the cause of action means. And what they said is that the determining factor in deciding whether the cause of action is the same is whether facts or evidence necessary to maintain the suit are the same in both actions. Now, that was explored in Delray Medical Center case, which is 5 Southern 3rd, 26, which is a 2009 case out of the 4th DCA. But in that case, what the Delray Medical Center court found is that there was actually the second application was different due to the repeal of a key administrative rule that affects the application, a review of the application. So as such, the second application was reviewed under a different standard than the first. In other words, the law changed. So you look at different criteria between the first application and the second. That's a substantial change in circumstances. In this instance, they were reviewed under the same standard. It didn't change. So the 5 criteria that were evaluated in the year 2000 are the same 5 criteria that this application would have been reviewed under in 2005. So the identity of the cause of action is consistent. Now, what they would say, and have said in their petition, is that it's impossible to ascertain whether the facts remain consistent because they were prevented from presenting any facts to the City Council. The City's position on that is that's an erroneous interpretation of the standard. The standard is whether the facts that are necessary to maintain the suit are consistent. So, what facts would you have had to show to the City of Jacksonville in order for it to approve or deny your application for waiver of road frontage? Those criteria didn't change. So that identity of the cause of action is actually consistent between the two. And finally, the last point that I wanted to raise to the panel today is the last issue that they raised, or have a problem with, is the identity of the quality of person's order against whom the claim is made. Their position is that in 2000, the decision was made by the Planning Commission. In 2005, the decision was made by the City Council. So what they're saying is because of that decision maker difference, that the identity of the quality of the person isn't present. The City's position on that is the bottom line is it was the final decision of the City of Jacksonville. When a local government is sitting in an administrative role, as far as the appellate rights go, it's the City of Jacksonville who is the real party in interest, and all the court has to do is look at the caption of the case to know that that's true in this case. Thank you.
Your Honor, I would proffer to the court that the vast majority of the argument that was presented had to do with the merits of the application, and we did not reach the merits. That's agreed by both parties. It was decided on administrative res judicata. There is a significant change between the 2000 order that was given to Carol Olson and the legislative ordinance that was enacted as a result of the res judicata, finding of res judicata. And that difference is that if you would have appealed this order, you would have appealed to the City Council prior to going to the Circuit Court. So you would have been given a double appeal before you've gotten to the District Court of Appeal. Now, because the city is making a final action, and that final action was this legislative ordinance, which we believe was incorrect. We believe they needed to have an order rather than a legislative enactment, that you would appeal that by writ of certiorari for first-tier review by the Circuit Court. When it gets to the Circuit Court, there's a second issue that comes to bear, which the Circuit Court is required to do 3 things. They're required to determine whether or not the proper law was required and followed, whether or not procedural due process was afforded during the quasi-judicial hearing, and whether administrative findings and judgment were supported by the competent substantial evidence. If you look at the order is silent to 2 of the 3. The order is silent to whether or not procedural due process was afforded during the quasi-judicial hearing, and whether administrative findings and judgment were supported by competent substantial evidence.
Do you then agree with the representation of counsel that as to the factors they utilize in reviewing this application for waiver of minimum road frontage, that you didn't set out in your application, your 2006 application, any changes in those factors?
No, I disagree, because those factors go to the merits. Once you get an argument on your merits, you begin presenting the evidence, and your evidence is you have this permit, you've done this to the property.
It goes to the merits often.
Well, in this particular instance, res judicata did not go to the merits. And it's agreed in both pleadings that the decision was decided, the determination was made premised on res judicata prior to getting to the merits of the application. So they did it administratively. They said there's no substantial change, which we think, and we proffer to the court, that is the wrong standard. The wrong standard is clearly in the first DCA with Doheny, as supported by Thompson, by the Florida Supreme Court. And that's very simple. Before you get to these 4 factors, you've got to look at whether or not there has been a new facts, changed conditions, or additional submissions. And that's in the record. Even the chairman in the LUZ committee acknowledged new submissions, a 100-page application, acknowledged that there were new owners and that 5 years had elapsed. Never, and in either pleading, was the application looked at. None of these 5 factors, the 5 criteria, were never applied to the new application. Never on the merits. Administrative res judicata cannot be the underlying basis using the Coral Reef and Metropolitan Dade line of thought, which we believe was superseded in the first DCA by Doheny and definitely by the Supreme Court.
Okay, thank you very much.